everyone, and thank you so much for joining us for today's webinar. My name is Dustin Saldarriaga. I'm a senior associate at Scott Legal PC, and today we are going to be talking about employment-based green card options. And some of the topics we'll touch on are the EB1, Extraordinary Ability Green Card, the EB2, including the National Interest Waiver, which is a great option for entrepreneurs, the EB2 and EB3 PERM options, which we'll talk about, as well as a brief mention about the EB5. We'll answer questions such as regarding the labor certification process, the PERM process, and the general process of applying for a green card. We are very fortunate to have my colleague, Kelly Legrand-Wiener, who is a partner at the firm, presenting for you all today. And Kelly has extensive experience regarding all of the topics that we'll be talking about. Before we get started, I do want to touch on a few things. The first is that our firm, although we do focus on business immigration, we are a full-service immigration firm. So we handle family immigration cases, we handle humanitarian cases, green cards, as well as non-immigrant temporary visas. So we encourage you all, if you have any questions at all regarding U.S. immigration, please do reach out to us. We'd be very happy to help. This webinar is part of a series. We do typically a couple of these a week, and they are on a variety of topics. So we do hope that you'll join us for future webinars. After this presentation, we'll be sending you an email, which will contain a link where you can sign up for future webinars, as well as a link to our YouTube channel. On our YouTube channel, we post full-length webinars, including this one. This webinar is being recorded. We also post shorter videos to our YouTube channel, and again, these cover a variety of immigration topics. Please do check those out if you think they'd be helpful. That email we'll send to you will also have a copy of the PowerPoint presentation that you see on your screen. If you do have a question during today's presentation, please send it to me through either the chat function on Zoom or the question and answer function on Zoom. I will be actively monitoring those, and I'll probably save questions for the end of the presentation, but we do plan to get through all questions by the end. So don't hesitate to send in any questions. And again, as I mentioned, this webinar is being recorded. All right, without further ado, I will go ahead and pass it off to Kelly.
Thank you, Dustin. Perfect. So as Dustin mentioned, we're going to talk about just kind of some of the main employment-based green card categories today, with a specific focus on the EB2 and EB3 PERM process. But to get started, we want to just kind of provide a general overview of some of the other very popular, green card options based on employment. So we have the EB1A, Extraordinary Ability. This is for people who have reached the very top of their field and can demonstrate sustained national or international acclaim. We have entire other webinars that kind of focus just on Extraordinary Ability visas and also Extraordinary Ability green cards, of which the EB1A is one. So I would encourage you to check that out if you think that's a green card option that would be, relevant for you. There's also the EB1B, Outstanding Researcher and Professor. So this is for people who are coming to the United States, to work in academia and the university system. There's the EB1C, Multinational Manager or Executive. So very commonly, people who maybe are on an L1A visa as a manager or executive may transition to this EB1C green card. Very similar requirements to the L, in the sense that there have to be two companies, one in the US, one abroad, with a qualifying relationship. And then, you're working as an executive or manager abroad, and you're being transferred to the US to be an executive or manager. We have the EB2, and there's two kind of subcategories within the EB2. So as a threshold matter, anyone who's applying for the EB2 needs to have either an advanced degree, meaning a US master's degree or higher, or the equivalent, or exceptional ability in their field. And then within the EB2, you can either get this through company sponsorship, so through the PERM process, or you can self-petition through a process called the National Interest Waiver. And this is where you ask that the government waive the normal requirement of the labor market test based on the fact that you are working on an endeavor of substantial merit and national importance, and that you yourself are well positioned to advance that endeavor. And similarly, we have separate webinars just focused on the National Interest Waiver. There's the EB3, so this is for professionals, and then skilled and unskilled workers. So each of those has a definition. So professionals is any job that requires a U.S. bachelor's degree or higher. Skilled labor is any labor requiring 2 years or more of education, training, or experience. And then unskilled workers is anything requiring less than that. And you can get this green card through the PERM. So that is company sponsorship. A U.S. employer is sponsoring you for a green card. We won't talk about the EB4 category today. This kind of covers a lot of different, kind of options like religious visas and things like that, but we're not going to talk about that today. And then we'll touch briefly, the EB5, we'll just mention, and again, we have separate webinars that go over this in much more detail. This is based on investment, where you're going to be investing either $800,000 or $1,050,000 into the United States, and then creating 10 full-time jobs. So lots more to each of these categories. But today we're going to kind of dig a little bit deeper into the EB2 and EB3 PERM processes. All right. So what is the labor certification process? What is a PERM? So the PERM is the main process by which, workers, employees in the United States working on temporary visas are sponsored for permanent green cards. And this is done through the EB2 and the EB3 category. The EB2 category, as we mentioned previously, you qualify for that category if you have either an advanced degree, so a U.S. master's degree or higher. The equivalent would be a U.S. bachelor's degree plus 5 years of progressive post-baccalaureate experience. That can be evaluated as equivalent to a master's, or exceptional ability. For EB3, you can, qualify with, just a bachelor's degree if it's a professional's position, or even with just, experience if it's a skilled or unskilled workers petition. So when we talk about, company sponsorship, sometimes, we have many clients, for example, who are here on E2s, maybe their spouse has work authorization, and can be sponsored by a company while they're here on the E2. So always good to think about all those options if you're, considering a green card and here on a temporary visa. So the PERM is a 3-step process. The first and the longest step is the actual PERM, the actual labor market test. Then there's the I-140, which is a petition that's filed with U.S. Citizenship and Immigration Services. And finally, the I-485 or Consular Processing. That's the actual green card application, and that's done at the very end. So let's talk a little bit more about the PERM. When you start the PERM process, the company has to draft what we call a PERM compliant job description. And, most job descriptions maybe are going to ask for, the ideal candidate, lots of, strong communicator, like lots of kind of subjective factors may be included in a job description. But for the PERM, the government requires that the company only ask for the minimum requirements to do the job in a reasonable manner. So they want to know, basically they want to make it as open as possible to the U.S. labor market to be protective of U.S. workers, to say to the company, if you do want to hire somebody who's not a U.S. worker, prove to us that you cannot find a U.S. worker in the United States who could do this job. So once you drop the job description with those minimum requirements, then you would file what's called a prevailing wage determination with the Department of Labor. So this is going to be based on wherever the job is located, what the job requirements and the job duties are. The Department of Labor will come back and say, okay, we think it's this occupation code. And then based on the wages in that area, this is the minimum amount that you have to pay this person once they get the green card in the future. Once you get the prevailing wage back, then the company can actually start the labor market tests, also called the recruitment process. So that's where they're actually going to post advertisements, and the regulations are specific about where all the advertisements have to be posted. So they're actually going to post advertisements, receive resumes, document receipt of those resumes, and then interview any applicants who seem like they may be qualified. If any willing, qualified, and available U.S. workers are found during this process, then unfortunately the process does have to stop. The employer is not required to hire any of those people, of course, but it can't proceed with the green card sponsorship anymore at that point. The company could potentially pause and then maybe retest the labor market at a later time. But if you make it through the entire process and you did not find any willing, qualified, and available U.S. workers, then you can go ahead and file the PERM with the Department of Labor. We have a bullet point here about audit triggers. So this means that when you submit your labor certification, what you're submitting is a form that says, yes, I did everything I was required to do. I posted all the ads, I interviewed all the applicants, but you don't actually submit the resumes or any of the proof of that recruitment to the Department of Labor at that point. However, if your case is audited, you can be asked to submit all that documentation. So for every employer, when they go through this process, one thing you create is called an audit file. So that's where you keep, the newspaper clippings, anywhere that you posted the ads, you have to, keep the proof of that. And then that becomes part of the audit file and may eventually be submitted to the Department of Labor if they do audit the case. There's certain, triggers that can cause the Department of Labor to look at the case with more scrutiny. So, for example, if the job requires a foreign language, this is a way employers sometimes will try to eliminate, U.S. workers. So if it's not very obvious why a foreign language is needed, for example, it's not a job for a Spanish teacher or something like that, you can't expect that a foreign language requirement can be, can make it more difficult. Similarly, any requirements outside of what's normally required, the Department of Labor has their own internal system for what they think is a normal amount of experience and education for any particular occupation. And if the company is asking for more than that, then they may have to justify it and explain the business necessity for that additional requirement. In terms of timing, right now, unfortunately, this process is taking quite a long time. The Department of Labor is taking about 6 to 8 months just to issue prevailing wage determinations. When you do the recruitment process, at a minimum, that has to last for 2 months. And then once the case is submitted to the Department of Labor, they're taking about 13 months right now to just review the case. And if the case is audited, you can add several months onto that. So it is quite long right now because of Department of Labor, processing times. They do fluctuate. So, over the years, sometimes they've been significantly better, but for now they are quite long. Once you pass this process, this very long first PERM process, then you're going to go and file Form I-140. So this is a petition that is filed by the U.S. employer, and it says that they plan to sponsor the employee for the green card. A benefit to this form is you actually can pay to get premium processing done. So you can actually pay an additional fee to get an answer on the petition within 15 business days. Additionally, the documentation submitted, is much less so than for the PERM. So you're going to submit proof that the company has the ability to pay the prevailing wage. So tax returns, audited financials, public reports, things like that. And then also you're going to submit proof that the applicant meets the requirements. So for example, if the job required a bachelor's degree in business and 2 years of experience as an analyst, you would need to submit proof of the applicant's bachelor's degree and then employer experience letters from prior employers showing that they had that experience at the time that they were, hired into the company. Once you reach that, once the I-140 is approved, now you're at the green card stage. So the green card stage, if you're in the United States, you're going to file what's called Form I-485. If you are not in the United States, you'll go through consular processing, and we'll talk about that much more in the next slide. But I do want to flag just timing here. In order to move forward with the green card step at this stage, you have to have a priority date that is current. And so that means that when you look at each month, the Department of State releases something called the Visa Bulletin, and it lists kind of each of the green card categories and shows whether they are current. If it is current, then it means that there's an immigrant visa immediately available, and you can go ahead and file your green card application right away. Or if it's backlogged, so if there's, there'll be a date there. And until your priority date is current, you cannot go ahead and file your green card application. So like, let's say hypothetically, if your category was current, you could even and you're in the United States, you could potentially even concurrently file the I-140 and the I-485. But right now, all the, the categories for EB2 and EB3 are backlogged, not just, they've been backlogged for nationals, or people born in India and China for quite a while, but now they are backlogged worldwide. And so it is a situation where, we'll talk about this a little bit more later, but you do need to be thinking strategically and planning for, do you need to extend your underlying status in the United States, or do you need to plan to perhaps leave for a bit? Because ultimately you may get to the I-140 stage, get your approval, and then really maybe just waiting for a period of time before you're able to file your actual green card application. And then also for family members, just to mention that with your, again, we'll talk about this more later, but that your green card application, you can include your spouse and any unmarried children under 21. All right, let's talk a little bit more about the green card step. So this can be done in two ways. One is called an adjustment of status. So that's done from within the United States. And the other is consular processing. So that's where you're going to go to a U.S. consulate abroad, usually in the country where you're residing or, most recently resided if you're still in the U.S., and get the green card through that process. With an adjustment of status, what you're going to do is file a form called the I-485 with U.S. Citizenship and Immigration Services. Once this is filed, you're allowed to remain in the United States. So even if, like, let's say you're on an L visa and you file the I-485 and then your L visa expires, you're still permitted to stay in the United States on the basis of the pending I-485. You also, when you file this, can file for work and travel authorization. So it is important to, during this process, if your underlying status does lapse, you want to make sure you have your work authorization card if you're going to continue working. Similarly, any travel, except unless you're on an H-1B or an L, once you filed the adjustment of status application, you cannot travel except with this special travel authorization from USCIS. So if you are going to do an adjustment of status and you're not on an H or an L, you do need to feel comfortable that there is going to be a period of time, several months where you won't be able to leave the United States. You will need to stay while you're waiting for that travel authorization to come through. At the end, many applicants will have an interview with the USCIS officer. They may ask for updated information about, the job or your employment, and then any questions, about your application to ensure that you're admissible, to the United States. So this option is really best for people who are already living in the United States here in a valid status. Very often, if you have children, going to school here, your spouse is working here, filing an adjustment of status is likely the best route. Another route is consular processing. So through consular processing, this all happens outside the United States. And so, whereas the I-485, if you file it, it gives you the ability to remain in the U.S. If you do opt for consular processing, you're not going to be able to remain in the U.S. based on that. So you would either need some temporary underlying status, or sometimes, maybe you're outside the United States, living there because you don't have an underlying status and you're just waiting for the green card. So under this process, what will happen is after the I-140 is approved, the approval gets sent to the National Visa Center. You will then submit biographical, information, on something called Form DS-260, and then also your documentation, birth certificate, marriage certificates, things like that. Once the National Visa Center reviews the documents, they will then send the file to the U.S. consulate that's processing your green card. They will call you for an interview. You'll attend a medical exam prior to the interview. You'll go to the interview. They'll ask you similar questions to what would happen at the I-485. And then if the case is approved, you'll get an immigrant visa stamp in your passport. You'll have to enter the United States while that immigrant visa stamp is still valid. Usually it's valid for 6 months. And then once you're in the United States, your green card will be mailed to you. So this option, is, often taken, let's say somebody's in the US, not on H or L status, and they have to be able to travel just for business. There's just no way they can stay in the US, for any period of time. They may opt for consular processing. Similarly, sometimes, you may be in a situation where just because of, logistics, you're not able to get some other underlying status. And then you can also wait outside the United States and process your green card at the consulate. All right, so a very popular question, during this process is who can pay for green card fees? And the fees, it's very clear that the fees related to the PERM process, legal fees and other fees, for example, the fees related to like paying for newspaper ads and things like that, all of that has to be paid by the sponsoring employer. It cannot be paid for, by the applicant. So that is something to keep in mind. However, once you get to the point of the I-140 petition and the I-485, it is possible, the employer or employee can pay depending on what they agree to. All right. So another important thing to be aware of if you are going through the green card process is dual intent. So dual intent visas, the explicit dual intent visas are the H-1B and the L. We list O here because it's kind of a quasi dual intent visa. Sometimes they treat it more favorably than some of the other visas that have higher standards for non-immigrant intent. So what dual intent means is that many non-immigrant visas, when you come to the United States, they're only granted to you based on a statement that you plan to depart or that you have maintained a foreign residence abroad. So you have to show that you don't intend to come to the United States permanently in order to qualify for this temporary visa. So if you're on a dual intent visa, it means that it's permitted for you to be on the temporary visa and to simultaneously have the intent to reside permanently in the United States. So when you're going through the green card process, it can be beneficial to be on one of these visas, an H-1B or an L specifically, because there's not any concern, like when you're in the green card process, if you're on, for example, a TN visa, this has a very high standard for proving non-immigrant intent. You do have to show you have a foreign residence you don't intend to abandon. Therefore, if you're on the TN and suddenly an employer is filing an I-140 for you that says we plan to sponsor this person to be in the U.S. permanently, it may be very difficult for you to renew your TN or to extend your TN because now there is documentation that shows you do have the intent to reside in the U.S. permanently. So it can be beneficial during this process to be on a dual intent visa if it's possible. That being said, it certainly is possible to transition to a green card from a TN. You just need to be more thoughtful and strategic about when you're filing, which documents. You may want to indicate on the I-140 that you plan to consular process so that you would be able to explain to the officer, well, look, on this particular entry, I do have temporary intent. While I have a green card petition pending, I plan to process it outside the US. And intent is assessed at each entry. That being said, you may find an officer who's not as receptive to that argument. So if it is possible to be on the H-1B or the L, it can be very helpful. All right, so let's talk about some other considerations, when moving from a visa to a green card. So one is timing and underlying status, which we've talked about a bit earlier in this presentation. So when you're going through this process, you want to think, long-term, how much time is left on your current underlying visa? If you're on your H-1B, where are you in the 6 years that you're granted? If you're on an L-1A, are you going to run out of the 7 years? If you're on the TN, you want to think about when are you filing an I-140 petition or when are you filing a green card application? Because there's some visas that you're just not going to be able to renew or extend, once you get to that phase where an I-140 or a green card petition is filed. So if the goal for you and your employer is that you're going to go through this process with never having any break in work authorization, you do need to plan kind of in parallel what's going to happen with my underlying temporary visa status while I'm waiting for my long-term green card. And, for things like, for some visas like the H-1B, if you are in the green card process, if you're at a certain stage in the green card process, then you can extend beyond the 6 years. So if you are in an H-1B, you want to be having those conversations with your employer to make sure that there's a plan in place to file the PERM with enough time that you'd be able to take advantage of those extensions if needed. When you're thinking about this, also consider, do you want to adjust status in the US? Do you want to get the green card through consular processing? What are the timelines for each? Very often, discussing with your children and your spouse, what are everyone's plans? What are the travel needs? What are the needs to be able to work in the United States? And kind of planning accordingly based on that. For your family, if you want your children to also be able to have the green cards based on your application, you want to consider filing early to avoid them aging out. So once they're 21, they won't be able to, or married, they won't be able to accompany you on your green card application. So it can be better to plan for this earlier rather than later, so you're not in a situation where your child is then needing to find their own visa status because they're not able to be a dependent on your green card application. All right, so let's talk a little bit about the green card interview. So for a while, it was very, very common for USCIS, during the previous years. They started interviewing people on employment-based green cards a lot more. They've since pulled back on that. It's become less common, but it's still always a possibility. And if you do the green card process through a consulate, you will always be interviewed. So prior to the interview, you want to review your immigrant visa petition. So you want to review the I-140, you want to review the PERM, whatever your employer has made available to you. You also want to review your own green card petition, the I-485 forms or the DS-260 forms. You want to organize and you want to print all the documents to bring with you to the interview. So usually the interview notice will contain a list of documents they'd like you to bring, usually copies and originals. So things like birth certificate, you want to bring the original with you, but you also have a copy. They should have a copy as well, but you want to have it just in case. You want to ensure that your medical exam has not expired. So they used to expire after 1 year or 2 years. Now, thankfully, they do not expire anymore. So that was a nice, recent change they made. You want to get updated proof of your employment. So especially if you're currently working for your sponsoring employer, they may ask to see, proof, of that. They may ask to see, proof of what, an updated letter or something called an I-485 Supplement J. If you're adjusting status in the US, they may talk about, have you maintained your status? So generally, if you've ever violated your status, you're not eligible to adjust status in the United States. So they will look back at your entire immigration history. Thankfully, for people in the EB2 and EB3 categories, they can take advantage of something called INA 245K. So if in the past, let's say maybe you were you had you had a minor status violation, you overstayed a day, something like that. Normally that would be a bar to you adjusting status. You would have to get your green card at a consulate. However, for these categories, what they'll do is they'll only look back at your most recent entry. So if you've, been traveling in and out of the US and you entered, 3 months ago, as long as you haven't violated your status, for more than 180 days within that most recent entry, you can still go ahead and adjust status, even if there's been some previous violations. We also recommend that you meet with your attorney and do a practice interview. Even if you feel very comfortable with the information, these are can be nerve-wracking interviews. So better to be prepared, think about how you're going to answer the questions, so that when you go to the interview, there's not any issues, based on that. All right. So what is porting? So another very, very common question, can you change employers during the PERM process? And if you do, kind of what benefits can you take with you from the fact that an employer has filed this PERM for you? So generally, there's not much benefit that you get until relatively late in the process. So if you are at an employer and they've started the PERM process for you, and then you get a new job offer and you change, you transfer your H-1B to a new employer, you really don't get any benefit from the fact that another company filed a PERM for you. At a certain point, if your I-140 is approved, if you get an I-140, you will get to utilize that priority date. However, it's like even if you go to a new employer, even if you have this priority date you can use, it's an older priority date, the new employer still has to start the whole process over for you. They still have to file a new PERM, a new I-140, and green card application. However, if you reach the point where you have gotten through the PERM, the I-140 is approved, and you have filed your I-485 and it's been pending for 180 days, at this point, you actually can port to a new employer as long as the new job is in the same or a similar occupational classification as the job that was approved through the PERM. So what you would do here is you would submit an I-485 Supplement J to U.S. Citizenship and Immigration Services with a porting request that basically shows that, here's the new employment and provides details explaining, why it should be considered the same or a similar occupational classification as the PERM job that you were previously approved for. So the real benefit here is the new employer at this point does not have to complete a new PERM. They do not have to complete a new I-140, but it does mean, this is something that's only available once you're relatively far into the green card process. Perfect. And finally, another common question, can I change employers after I get my green card? So the answer is yes. You can change employers after you get your green card. You're not locked into working for the same employer for the rest of your life. That being said, when you obtain this green card, you're making a good faith attestation that you intend to continue working for the sponsored company. So if you get your green card and you quit the next day, this is something where if you naturalize in the future, if you're submitting any documentation to the government asking for an immigration benefit where this might come up, they could look, they could look back and say, were you being honest, were like with your green card application. So it would most often come up if you're going to naturalize, they would look back at your they look back at your green card application, and they look back at your employment history, and they may have some questions about it. So very unlikely that they would take steps to revoke your green card, but you don't want to do anything that would indicate there was any potential misrepresentation or any fraud when getting your green card.
I'll bring back up the screen. Sorry about that, Kelly.
No problem.
So while I'm doing that, I just wanted to quickly make a note. I haven't received any questions, so if you all do have some questions about anything that Kelly has mentioned, please don't hesitate to send those in. All right, let's get that back up. I apologize for that again.
No problem. I think we're just at questions and answers, so we've already
perfect.
reached the end. I see someone has raised their hand a couple of times, but if you do have a question, feel free to kind of write it in, and we can look at it. Otherwise, I think we'll close.
Perfect. Yeah. Perfect. Okay. So yes, as Kelly mentioned, go ahead and use the chat function or the question and answer function on Zoom, and we'd be happy to answer your question. So, excuse me, Kelly, a question came in. Is cross-chargeability recommended or possible if the priority date is not current? I'm
not sure I understand the question. Yeah, I mean, cross-chargeability essentially means like you can utilize the if you were born in China and your spouse was born in Pakistan, like you can utilize that. So I think cross-chargeability can be a great tool and something that can be used, but would only become relevant when when you were then able to, like, when the current worldwide priority date allowed you to do it. So I think it's a great tool, and you can use it when it's relevant.
Perfect.
Is the priority date for EB2 under NIW the same as published in the visa bulletin? So a priority date is something that each applicant will get. So if let's say your company is filing a PERM for you, your priority date, like let's say everything gets approved, your priority date is going to be the date the PERM was filed. The dates that are listed on the visa bulletin are dates that those are like your priority. You have to look at your priority date, and then you have to look at the visa bulletin date to determine whether or not you are then allowed to file your green card application.
Right. And then when you're looking at the bulletin, the second category would include both the PERM and the NIW categories, right? Perfect.
Yes. Yeah.
Perfect.
Someone did mention here a TN visa is not in dual intent. It's not ideal. It's a very slim chance. I will say I don't the TN visa it doesn't have dual intent. And it is, so yes, it's not ideal necessarily to adjust status under the TN, but it is very possible to do. We do have people that have done it. So it's not something where because you're on a TN, you're not able to adjust status. You can, it's just, it can be riskier, and you want to think about the timing more, more specifically.
Great. And Kelly, another question came in. Is there an age limit regarding filing for a particular visa? They use the H-1B as an example, but I think an additional example may be, if you're nearing retirement age, for example, and you're going for an employment-based green card. Can you speak to that?
There's not. I mean, all the same kind of employment discrimination laws, apply here. So there's not an age limit. Whether or not companies internally have their own, policies that may be not aligned with what the law is, I couldn't speak to that certainly, but no, there's nothing in the law that says there's an age limit, for this. Someone is asking an EB2 under NIW self-sponsor. So yes, you can self-petition. You can have an employer petition for you, but functionally, it doesn't really make sense to do that. My daughter will be 21 years old soon, but doesn't live in the US. She'll be living in the US soon. Can she apply for me? If she's a US citizen, and meets the other requirements, then if you have a US citizen child who's 21 and is living in the United States and meets the other requirements, then yes, they can sponsor you for a green card. So I'd say these are getting a bit outside the scope of what
Right.
so something's asking about a FOIA. So, we really limit the questions to kind of what the purpose of the webinar is, which would be, PERM, employment-based green cards. If you do have immigration questions, please feel free to go ahead and set up a consult with us. We'd be happy to discuss with you.
Absolutely. So the priority dates under EB2 and the visa bulletin are published for no. So
the same.
Yeah, the second category in the visa bulletin includes NIW and PERM. Perfect. So as Kelly mentioned, if you have any other questions, please don't hesitate to reach out and schedule a consultation on our website. We do hope that you found the presentation helpful. Kelly, thank you so much for sharing your expertise. We hope to see many of you on future webinars. Have a great day in the meantime. Thank you.
Thank you.